All present, again, before the honors of justice, the appeals court, now sitting in Boston, Vuono, within the Commonwealth. John Dan, give your attendance and shall be heard. Within the Commonwealth of Massachusetts, this court is now open. Please be seated.
Good morning. All right, well, thank you both for being here. Whoops, excuse me, I have a little. All right, can you hear me now? Okay, thank you both for being here. I'm going to start by introducing the panel to you. To my right is Justice John Englander. To my left is Justice Andrew D'Angelo. My name is Ariane Vuono. We're here on an expedited appeal in the case of 2025-1046, Dominion Builders, LLC versus HENNEP Properties, LLC, and others. Ready to hear your argument?
Good morning. May it please the court. Peter Carr for HENNEP Properties. Your Honors, I'm not going to repeat everything that's in the briefings, and I appreciate the opportunity to address the court today. But if I may offer just 2 points for your consideration in addition to what's in the briefs. Of course, any questions as well. Number one, DAG has never argued an ambiguity in Section 11 of the Massachusetts Arbitration Act concerning confirmation. As we've argued, that precludes the need for any extrinsic evidence or extrinsic help. It's not permitted, it's not necessary. The cases we've cited indicate that there's an essence of finality to the word award in the Murphy versus National Union case and the Mass Correction Officers case.
Where does that get you?
That the statute confirmations.
You're jumping in the middle, which is usually fine, but frankly, I have difficulty following your argument, having read it pretty thoroughly and thought about it for a long time now. Where does it get you that there's an ambiguity in the word award? To take the logic of your argument. This is the argument that there was no jurisdiction.
Right. So yes, Your Honor. So Section 11, the confirmation section of the statute, says award. This was an order. This was an interim arbitration order. This was not an award.
So that, it seems to me, hurts you, because the single justice under the packaging industry's case has jurisdiction over any interlocutory order.
That I understand, Your Honor, and I don't disagree with that.
So if the single justice has jurisdiction, that's the end for you, isn't it?
No. Now I understand Your Honor's argument.
Okay.
So under Section 18 of the Mass Arbitration Act, the legislature said the denial of a confirmation order, or denial of confirmation under the Massachusetts Arbitration Act is immediately appealable.
Okay,
that has to go to a 3-judge panel.
Award. An award.
An award.
Not an interim order.
That's correct.
Okay.
That I agree with.
So back to Justice Englander's point then, where does it get you?
So it gets me that if there was single justice jurisdiction, and I don't concede that there was, but if there were, then the single justice and DAG are confined to the statute, Section 11, that talks about confirmation of an order, of an award, and therefore the court should not have granted the relief that it granted in that case.
Aren't you ignoring the fact, as the single justice in this case explained, that there are exceptions, and the exceptions are set forth in federal cases of which we're going to follow?
Yes, and my position is that the court need not look to those federal court cases because the Section 11 of the Massachusetts Arbitration Act specifically says award. It does not say interim order. So my position is, and that is my argument is that you don't need to look at federal case law or construe the statute. The statute is the statute. That's what the legislature used. It did not use the word order, and this was
Stop. I can't tell what we're arguing. I, honest to God, can't tell what we're arguing, and that is a problem for you because there's a request for an award of attorney's fees at the end of this, and so your argument needs to be something that we can follow. So this is what I think, and I'm not sure where you want to start, but you're going to have to address this. What I think is that Chapter 231, Section 118 grants the single justice the authority to address any interlocutory order of a Superior Court judge. I think that this order is an interlocutory order of a Superior Court judge. Packaging Industries says that even though there could be an appeal taken to a panel, the single justice, if it's an interlocutory order, still has jurisdiction. If the single justice had jurisdiction here, then the order is okay, and your appeal from that cannot lie, again, under packaging industry and a whole lot of other cases. That's where I am. I don't know where they are, but help me. What am I missing?
Sure, I appreciate that. So I understand that Section 18 of the Massachusetts Arbitration Act allows for an appeal of the single justice's order to this court. That's how I construe that Section 18(6), because the single justice declared that the order was confirmable.
Well, she didn't say that.
No.
She sent it back to the Superior Court for the judge there to consider whether it was confirmatory.
Absolutely. And so when I use the word
I want to start even before Justice Englander, I think, which is what went before Justice Shin was whether what the Superior Court judge did was appropriate. She found part of it was, but then she sent it back for additional rulings.
Yes.
How is that not interlocutory? She made no final decision. She said, go back to the Superior Court. So how is that not interlocutory?
Because, and when I use the word confirmable, I agree that the court remanded it. I fought for remand, so I've never said otherwise. I said that confirmable meaning that an interim order of an arbitrator is subject to confirmation under the Act. That's what I meant by confirmable. I never expressed or implied that the single justice said that this shall be confirmed. I've never argued that. I've never said that.
So answer my question. How is that not interlocutory if a Superior Court judge has to consider something, whatever it is the judge is going to consider, and then make another order? How is it not interlocutory?
Because the single justice interpreted Section 11 of the Massachusetts Arbitration Act governing confirmation as allowing confirmation of an interim order versus what the language of the statute said, which is it says award. So my position is that order by the single justice, that decision construing the statute, which the single justice admitted or acknowledged was a novel issue, never decided under Massachusetts law, that order by the single justice is appealable to a 3-judge panel pursuant to Section 18(6) of the Massachusetts Arbitration Act.
Well, wait.
That's
Talking about Section 11,
Section 11 is on
not
confirmation.
Section 18.
Section 18 is the appeal provisions that the legislature
Are
has
you talking
indicated are
about
exhausted.
Section 11 or Section 18?
There's a question
I'm
before.
sorry,
There's
I
a
didn't-
specific question before you.
Yes, Your Honor.
Section 18.
Is the appeal provisions of the
Yes, I
Massachusetts.
got it in front of me.
Yes.
Okay. An appeal may be taken from an order confirming or denying confirmation of an award. And what do you take from that? So that has to do, by the way, with an appeal from the trial court. That's not an appeal from single justice. That's an appeal from the trial court. That's what they're talking about. If you think I'm wrong about that, you got to cite me a case.
And let me add, it also is referring to the award, non-interim order, correct?
So I'm looking at Section 18(6). That's what I'm relying upon.
Judgment or decree entered pursuant to provisions of this chapter.
Yes. So the single justice entered a decree pursuant to the Massachusetts Arbitration Act, construing the Act, Section 11 of the Act, is permitting the confirmation of an interim arbitration order.
You think this applies to an appeal from single justice?
I do, because the single justice...
Why would we construe it that way when we have case law dating back a long time that says that the single justice's orders are not appealable? That's what packaging industry says, right?
I agree with that. Absent
Okay,
absent
so
a
why
rule-
would we construe this general language of Section 18 to be changing that rule just for judgments or decrees of single justice in an arbitration case?
Because the case law says that there's no right to appeal an interlocutory order of single justice unless there's an exception. And the legislature has carved out, my argument is the legislature has carved out this exception to allow a 3-judge panel make the decision. And the reason why I make that further argument is because the legislature said that there's an automatic 3-judge panel right to an appeal of a confirmation order from the trial court. So it's presently executable under that Section 18. So usually if a trial court entered an order confirming or denying arbitration, that would be an interlocutory order of the trial court. Section 18 says...
Could you step back for a moment, because I'm sort of having a chicken and the egg problem here. Did you just say that when a trial court judge affirms or denies an arbitration award, okay,
Yes.
that is or is not appealable in your view?
That's immediately appealable to
Right,
this court.
To a 3-panel situation, right?
That
Okay,
says the legislature, that's correct.
all right. That's not what we have here.
Correct.
Okay.
What we have is, under Section 6, what we have is an order, a decree by a single justice declaring that an interim arbitration order is confirmable, subject to confirmation, under the Massachusetts Arbitration Act. You have a single justice construing rights under Section 11 of the Massachusetts Arbitration
What the
Act.
single justice has done is answered a question of law,
That's correct.
which she is entitled to do, which she has the authority to do, right?
Yes.
And as Justice Englander said earlier, after that happens, there is no direct appeal from that order. It goes back down, the proceedings are completed, and then there's another opportunity to appeal.
So my argument is that the legislature, because it wanted the fast track, number one, wanted the fast track arbitration decisions, under the Massachusetts Arbitration Act. Number two, the cases have held, the Supreme Court have held that Section 18 is the exhausted remedies for appeals in this Massachusetts Arbitration Act realm. So my position is that it serves judicial economy to allow a single justice appeal, an appeal of a single justice order of this nature to a
Okay.
3-judge panel so that this court can weigh in definitively.
All right, I now understand your argument. It's not one that's in your brief. I didn't see it anywhere. But let's assume you're right. That argument now says we have jurisdiction pursuant to Section 18.6
Yes.
over the single judge. So now instead of the principal argument that you made in the brief that I read yesterday, okay, which was we don't have jurisdiction, now it's we have jurisdiction. So now we would, under that theory, we would reach the merits of whether or not the single justice was right on the issue of the ability of a Superior Court judge to confirm an interim order like the one we have at issue. Is that right?
That's correct.
Which you didn't brief. I mean, the single justice's order addresses a half a dozen federal court cases that go against you, and you say in a footnote, I'm not going to address those. So help me. How would we resolve this question then that you, in my view, didn't really brief?
My position, Your Honor, is that the court need not look to the federal cases because the Massachusetts Arbitration Act at Section 11 is not ambiguous. So under statutory construction rules, you read the language of the statute.
So what statutory language are you
Section
relying
11,
on
I'm
now?
looking at Section 11 of the Massachusetts Arbitration Act, which says that only an award is subject to confirmation. And that's been my argument all along, that there's not the ability in Massachusetts to confirm an interim arbitration award. That was always been my argument, and
Are we talking about Section 11 or Section 18?
Section 11.
Okay, so I don't think I understood this, and I'm going to have to try to. Can you tell me exactly the language of Section 11 that you're relying on for this?
It's actually a page, I cited it and quoted that page of my brief. It is at
This is your
page
primary brief?
17. I made this argument.
Your
page
primary brief, not your,
my opening brief.
Okay.
It starts at page 16, and then it goes, I cite the actual language from the statute at page 17. So I made this argument in my original brief, and I apologize for the confusion over jurisdiction, because I always think that this court had jurisdiction. It was the single justice asked whether or not the single justice had jurisdiction over it. So I apologize for that misunderstanding. But I cited the language at page 17 of my brief,
17 of your brief.
my opening brief.
Hey, I'm still confused as to why we're even getting to the merits. Judge Shin, as single justice, concluded that it was error for the Superior Court judge to deny the motion on the ground that the interim order is not a final award, and she sent it back for further proceedings for the judge to consider other stuff. So we still don't have an actual order of the Superior Court because Judge Shin sent it back. So why are we getting to the merits of the underlying case when a Superior Court judge has still not, because of Judge Shin's order, made any order regarding that?
Because Judge Shin said that as a matter of Massachusetts law, the interim order is subject to confirmation. If this court rules that
But it hasn't been confirmed yet.
But the judge below is now, it's going to go back to the trial judge. If the trial judge now has the authority to consider whether or not to confirm the order, right? My position is, if this court rules that it's not, the act does not allow confirmation of an interim order, it's over. It doesn't have to go back.
What happens if if the Superior Court judge finds for you?
Well, that's a good question, and I'll tell you what.
That'd be a bad thing.
It wouldn't be a bad thing, but then perhaps, and this is where it got very convoluted, frankly, if DAG then appeals, right, they're appealing the judge's decision whether or not under the law that is implemented, Section 11, Massachusetts law, has been met, not whether or not, as a matter of law, it's been confirmed. I was concerned, frankly, of losing appellate rights to have the court consider on a further appeal whether or not confirmation was allowable as a matter of Massachusetts law. DAG has indicated that that may be an issue that would be precluded if it came back up. Furthermore, they've said they're going to seek contempt.
Well, how in the world would it be precluded?
I don't know. They've indicated I might have the ability to.
It says so.
Just because the other side says something, you're going to go back to the Superior Court. The Superior Court is, by a single justice order here, it's going to say, okay, I was wrong on one part of this case, but I have to make a ruling on other parts of the case. You might win. Great, you win. They appeal. Now everything comes before us potentially, because at that point, maybe it's a final order, maybe it's still an interlocutory order. I don't know. That would be if you win. If they win, you appeal and say that A, the single justice was wrong, and B, the Superior Court justice was wrong. I'm missing how it would not be appealable.
Because I read the statute as giving an immediate right to appeal of the single justice's decision on confirmation. So I brought it to this three-judge panel to decide that issue of law that was novel, as everybody understood. If this court says, no, we don't think that Section 11 Massachusetts arbitration.
Let me interrupt you. Did anyone think about asking a Superior Court judge to report a question?
I did not.
Okay. Yes, go ahead. Your time is up, and Justice Engler has more questions. Go ahead.
Yeah, I sure do.
Okay, no problem.
Now I'm starting to understand a different argument. I do see that it's in here. I underlined it, and I thought, that's interesting. I don't know why I would read it to preclude the ability to take the appeal to the single justice. I don't know why I would read this to preclude your opponent from seeking confirmation of the interim order, okay? Which is how you read it, right? Upon application of party, the court shall confirm an award. You say, well, that just grants ability to confirm an award, so what DAG tried to do here, they can't do.
Correct.
As a matter of law.
Correct.
Is it the same language as is in the Federal Act?
Yes.
As to which we have 6 courts that have said you can take that appeal?
My position is that this court need not look to those courts because the language in Massachusetts statute is unambiguous. So just applying our settled law, you don't go to extreme.
Did any of those cases address this argument that you're making, that the Federal Act only allowed the ability to confirm an award and not an order?
Not directly. They
So
talk
you
about
cite
finality.
no cases for this position. You just tell us that the word award necessarily excludes, by implication, the ability to take an effort to confirm an order.
I'm relying on the language.
Why
of the
would the
statute.
legislature? So now we're in sort of a legislative construction, a statutory construction effort. So let me ask you this question again, not briefed. Why would that be a good rule? Okay, they go to the court seeking interim relief that they say is absolutely critical that it be awarded. Okay, why would it be a good rule that the Superior Court could not confirm that?
It's because the cases teach that when parties to an arbitration, the court should stay out of it. That's why. So they
What
want
about a
finality
preliminary
before-
injunction? If I go seeking a preliminary injunction, so you're going to have to help me with this. Can I seek a preliminary injunctive order in an arbitration, or do I have to go to court on that?
You can go to the arbitrator.
I can go. So suppose I get an award of a preliminary injunction from an arbitrator. It's worthless without confirmation, right?
No, I would disagree because you could go back to the arbitrator and have it reduced to an award. That would then be, and that's what happened in the Charles River case that I cited the SJC.
You mean reduced to an award? I used the wrong word. I used the word award, but it would just be an interim order, wouldn't it?
But you can ask the arbitrator to reduce it to an award like they did in the Charles River case and the Supreme Court case that I cited. That was interim
What's the
relief.
difference between a preliminary injunction from an arbitrator and something that is, quote, reduced to an award? What does that,
Makes it appealable.
what does that mean?
It means that it can be confirmable under the statute. That's what it means.
So you're saying that this is a technical error on HENNEP's, on DAG's part, why didn't they just go and have this thing that the arbitrator called a preliminary injunction? Frankly, it doesn't look like one to me, but they made a technical error. They didn't get it, quote, reduced to an award before?
I don't know what they decided to do.
No, but this answer the question.
Yes, yes, the answer is that they rushed to the Superior Court, and it's in the record, because they wanted to go for contempt. That's what they wanted to do. So they rushed to get a confirmed order.
Intentions we can't care about because there's no findings, we don't really know. But did anyone ever say, did you say, oh, what you should do here is get your interim order confirmed as an award, and then we fit the legislative parameters without having to do any statutory construction, and we appeal. That, I don't see that ever having happened in the procedural history of this case.
I did not recommend to DAG to go get an award, but I indicated at the very beginning when I opposed their emergency motion for relief that there was no jurisdiction in the trial court because it was not an award, and that they needed to go, and I think I did argue,
Okay.
I don't recall.
I see your point.
That they should just go back to the arbitrator and have it reduced to an award, and then they could confer, fight about contempt later.
Is there any place that you could point me in the rules of the, for example, AAA, or in case law that suggests there's a difference between what the order that was entered here and what you call reduced to an award? Any place anybody explains, oh, no, the order you can't get confirmed, but you need to get an award, you need to ask for that. Where does it say that?
The only case I can cite for that is the Charles River case by the Supreme Court, because that was interim relief by an arbitrator, which they acknowledged was available, and they indicate that the nature of the relief that was entered, preliminary relief, was an award. And it's stated it's an award. So that's
So
my...
what's the cite to the Charles River case?
Yes, one moment. It is 412 Mass 14, and I cited it in my brief at page 20.
412 at 14?
Page 20, yep.
And the jump site is page 15, and I cited it in my brief at page 20. The court recounted Charles Construction Co. Inc. seeks enforcement of the interim arbitration award in one of the actions before us, and Darien seeks an order vacating that award in the other. So the cases that have allowed for interim, I don't deny interim relief an arbitrator, not one bit, I've never said that. And Charles River says that an arbitrator can have that authority if they grant it, but it's the distinction between an award and an order that I've been
While
fighting.
Justice Englander is reading, can you tell me, and I know this is almost putting you in the shoes of the other side, if they went back to the arbitrator, what would they ask for as the quote-unquote award that's different than the order?
I honestly, I don't know for
Wouldn't,
certain.
wouldn't the arbitrator just be able to say, okay, I change it from an order into an award?
I have in my...
Those magic words make it appealable.
Yeah, it makes it subject to confirmation under the language of the act. And I'll just tell you my experience, because I can't answer for DAG, I'll just give you my experience. I have had interim awards entered by arbitrators. I have done that. And in Charles River, that's what they did. So it's not a technical distinction. I'm not making some technical,
No, I understand,
funny argument.
so the award doesn't have to be monetary damages, it could be something else.
That's never been my argument, that they're
Okay.
not entitled to pursue the relief, and equitable relief that is subject to an award. That's not the issue. And the concern is that because the legislature has been very strict in how these rules apply, there had to be, I don't know why, but they drafted the word award in there. And there's no case that stands in Massachusetts that an order will be sufficient.
It just seems to me, again, Justice England's reading, so I'll ask. It seems like it's putting form over substance. If the word means the exact same thing, the arbitrator can do the exact same order and just change, goes back and says, I want you to make it an award. Okay, uses the exact same language, instead of order, throws in the word award. Boom, now it's confirmable. That just logically doesn't make a lot of sense to me.
I understand your position, Your Honor. I understand that well. But I'm just reading the language that the legislature used when it drafted the statute. And
Basically, what you're saying in terms of jurisprudence and practice, what lawyers do is just simply make sure that they can fit anything that they receive from the arbitrator in an interim basis, make sure it fits the word, and they use the word award in order to go forward.
that is my position. I
But
can't...
what if we were to say that's a fiction that we're not going to perpetuate any longer?
Your Honors, I appreciate the time, and I understand it's difficult, and I've never been accused of bad faith or frivolous. I'm really pursuing this appeal in good faith, and I'm looking at the language that's in the statute and the cases that have come out of this court and the Supreme Judicial Court, and the purpose of the whole scheme to make sure that the arbitration procedures work in harmony. That's how I'm looking at this. And I don't know what, form over substance or any of those arguments. I'm looking at the four corners of the statute and the case law that I'm interpreting in good faith.
Well, we totally appreciate that. Our job, though, is to look at form over substance, so we're pushing you for that reason. So we appreciate your answering our questions, but it's important that we understand all the different parameters and all the different scenarios, so that, because that is our job.
And I think that, Your Honor, to your point, because of the Murphy versus National case that I cited, where it says that confirmation in Massachusetts is understood to mean there's something to enforce, there's something to do, okay? It's in the nature of a final judgment, as I read the cases, and the Mass Commissioner case I cite. So in Massachusetts, there has been seen, as I see it, a distinction in implementation of what is a confirmable award. And so therefore, I don't think it's a technical defect or a technical argument. It's not
I
form
see your
over
point.
substance.
I'm gonna call this now. We've got
I know,
about
it's
13
been-
minutes over. No, it was our questions, and so that's fine. But I just want to be sure that Justice Englander has the opportunity to, no further,
set.
no further questions there?
I-
Thank you
I
very much.
appreciate your time
Thank you very
very
much for
much.
your time.
Thank you.
And we hope we don't go over as long with you, but be prepared.
May it please the court, your honors, Richard Briansky on behalf of Dominion Builders LLC, DBA, DAG. I think you understand what the issues are, and I'm very comfortable in relying on my brief and answering questions without sort of being duplicative of the issues that were raised. But those are predominantly the issues that we had raised in our brief, jurisdiction, and then substantively, we rely on sort of the same decisions that the single justice found to be basically uniform across all the circuits, interpreting a very similar, if not identical statute, the Federal Arbitration Act, and coming to the same conclusion.
What do you make of the argument of your brother that what you have is not an award, and because it's not an award, it wasn't confirmable?
I think that's elevating, and I was thinking the same thing, and I'm going to elevating form over substance, and I can't recall the specific federal cases, but this has come up periodically where there's, I wouldn't necessarily say a scrivener's error, but there may be some inarticulate description of the particular award. And what the court says, we're going to look at the form of the award itself, because this comes up oftentimes, even when you're talking about injunctions, it may be labeled an order, it may not have that particular language specifically, but the body of itself, the substance of it, allows the court to conclude what it really is. And here we have essentially an interim order. And I don't think the argument is at all compelling.
Well, the most compelling part of it is that it uses the word award, right? That's the language of the statute. And I just read quickly the Charles Construction case that your brother cited. Does that help us, hurt us, help you, hurt you?
I actually thought it involved an interim order.
It does too.
And I think they say,
I think it's kind of interesting because it seems to me that it says that you could get an interim order confirmed, maybe. Maybe you could. They decided as a matter of law you couldn't because they read the rules so that you couldn't get it, couldn't get the interim order that was granted, which was for prejudgment security, right?
yeah, and so here,
I'm not sure how the case helps your brother. Am
we
I
said-
missing something?
no, we said it in our brief, our affirmative brief, and the distinction here to be made, which I think is a significant one, is the AAA amended their rules. They specifically allowed for, and if you read the SJ decision, they said, well, we can't find where they allow for this particular relief in the rules. But here, they do, the AAA has amended their rules since the issuance of that decision. Rule 39 of the AAA rules specifically grants this particular form of relief, which is what we saw.
Whoa, careful. What particular form of relief? What do the rules say?
I quoted the rules, and I don't remember them verbatim, but it may say interim award. I know we said it in our footnote.
Well, where is it cited? That would help.
Don't see a footnote.
I was pretty certain we cited it in a footnote.
Well, I kind of would like to see it.
I was wrong.
There's no footnote other than footnote number 1, so you must be some,
It may have been in our interlocutory brief.
Okay.
But we can provide the court a copy of the
we-
rule.
We can find, don't worry about that. I think we can find, unless.
Let me go back to the word award and order, because it does seem to me, in one sense, it might not be just form over substance. When you go to the Superior Court and argue for contempt, the first element, I guess if I can call it that, is that a judge has to find that there is a clear order. So if it's only an award of an arbiter, can a judge make the finding that that is an order? The arbiter awards you $1 million. They don't pay, you go back, and the judge says, well, this isn't an order to pay $1 million because it doesn't say how long you have, how the payment is to be made. We need an order so I can find whether the other side is in contempt or not. That's kind of the same thing, isn't it?
Well, I think what you're talking about now is the substance of the language that's used in the, either you call it an award or you call it an order, but you're going to look at the plain language, and that some court is going to interpret whether it's clear and ambiguous and whether there was a violation of that particular, whether it's an award or order, but we're going back to the language of the particular document, whatever it's called. And so I again sort of go back to that form over substance distinction, because we're going to go back to the order. Either it clearly required specific conduct and there was a violation, or it didn't, in which case there's no contempt. But again, like what an arbitrator or a court ultimately labels it, I think is sort of irrelevant. We're going to go back to the substance, just like we would do if you were challenging a particular, and to me this is no different that comes up with injunctions, and that's, you know, judicially created, but you know,
What's judicially created?
An injunction. We would go in here if we were seeking like an injunction through the court system, and oftentimes a court may not, a superior court judge may not be as articulate with a particular order that they issue, and they may label it something other than an injunction, but it's still an order. And that order itself would be enforceable. It's enforceable through contempt if there's a violation. But I think there's case law that also very similarly, you know.
Can I ask, this is perhaps slightly off point, but the order says, I find that Dominion is entitled to immediate preliminary injunctive relief to suspend performance under the subject general contract. It's really a declaration, isn't it? It's not an injunction. An injunction says, don't do X. Sometimes an injunction says, do X. This doesn't say either. This says you can if you want to.
I mean, I admit it's probably not the most articulate form of award, but I think, at least it would be our opinion, it got us the relief we were seeking. The irreparable harm that we had alleged was the continued performance under the contract without payment. That order, at least the way I read it, allowed us to suspend performance without any reciprocal consequences, which was what we were asking.
Yeah, that last piece, that's the key, isn't it, for you? Without any reciprocal consequences. That's really what this whole fight is about, is 4 words you just added to the end of that.
That's probably accurate, and that would have been more articulate, but I guess I would, and I understand.
And I'm not saying that you're wrong about that. I wanted to make sure I understood it right.
No,
and that is, you read this to say, and you can't terminate us if we do.
Because otherwise, what would the point of the order be if they could then subsequently terminate us? Why would we have gone in if we were going to?
I get it.
Sorry, like I mean, to me that's like manifestly obvious why we would have gone in for the order, because we could have just stopped performance without the order and risked termination. But the entire, sorry, I know you get it. I'm not going to belabor the point.
That's why there's 2 others here.
This is a great legal argument, and the lawyers are doing a lot here. Both of you are doing a fine job. Is it fair to say that no matter what happens here, this case is coming back before this court?
I wouldn't necessarily say that. I'm optimistic that you know, it gets resolved in arbitration, which is where the substance is going to be resolved. The substance of the claims. What we sought is interim relief, and what we haven't been able to get, and why we're here, is to effectuate that interim relief to prevent the termination that actually occurred. And had we been able to confirm the award, then they take the appeal. That is really significant, that those procedural steps, because we would have had the relief that the arbitrator had intended. They would have had the opportunity to move on an expedited basis to appeal that confirmation order to the extent there was an issue. And I also think that's really significant when you're evaluating the argument as a whole. I mean, that confirmation works both ways. One, it allows me as a party who's looking for the relief to get the protection of the court, but secondarily, which came up in the argument, it allows the opposing party to challenge the award through the appeals process, and it gives them that immediate right to appeal. They can both go to the full panel, or if it's an emergency, they could, well, I don't know if they would be able to go to the single justice. I'm not going to get into that issue, but there's certainly relief.
It might be back here.
I'm not going there.
Stop being a single justice in 4 days. Do whatever you want.
Yeah, Yeah, but I think that's the point here, that there's bilateral rights that come from the confirmation of the award that both benefit both parties, and that's really significant here with an interim award. Otherwise, if you're the party who has been harmed by the award, there's no mechanism to appeal the award other than through a confirmation process. And so, anyway, I'm going to stop myself. If the court has any further questions, I'm here to answer it. And we sort of.
Do you think there's a difference between the word award that's used in the statute and the word order that's used in the document that you're trying to get confirmed?
No. I think, at least in my opinion, they're one and the same. I will say this, if you're looking at 251, Section 18, I do think the legislature made a distinction between award and judgment. If you look, the 5 enumerated sections all mention the word order, order, order. The last section mentions judgment. I think that is significant because I think the 5 articulated orders are all interlocutory types of decisions. The 6th is a final decision, judgment, award. I think it also references 251, Section 14, which also says judgment and decrees, which refers to a final award or a final decree. And this sort of, sorry, this is not the answer that you were probably looking for.
I don't follow. You think that 1 through 5 are interlocutory?
Well,
an order confirming an arbitration award. Why isn't that a final judgment?
Because it says order. I mean,
it says award, doesn't say order.
Well, I look at the 1 through 5.
I'm looking at 3. Oh, it says both order and award. Yeah. That's interesting.
An order confirming an award.
Order confirming an award, but if you look,
which is what you sought. Which is what you sought.
An order confirming an award.
That's what you sought in the Superior Court. An
That's
order
correct.
from the judge confirming the award of the arbitrator.
That's correct.
Which we have also substituted and called that an interim order during the course of this argument. So
Yes.
we need to be careful about that. Okay, all right.
Well, that's what I'm referring to,
Yeah.
that one
Okay.
document, however you want to call it, that's what I'm referring to. But I think if you're reading Section 18, you also have to read it in conjunction with Section 251-14, which says judgment or decree. And I think when you read them both together, because if you read 254, Section 14, it says, upon the granting of an order confirming, modifying, or correcting an award, judgment or decree shall enter. And then if you read that in conjunction with Section 6, you're
Right,
talking
but
about-
you see, if you do that, I'm inclined not to read things quite as technically as. So the problem starts with, what is the Superior Court proceeding, right? I mean, it's some kind of miscellaneous docket, right, where somebody says, I have this arbitration, now I'd like you to confirm it. Are they asking for more than an order? Are they asking for a final judgment? I'm not sure that the legislature was as precise as you are suggesting it was by using the word judgment in 6 and order in 3, because I don't know the answer to this question, but my guess is someone enters something called a final judgment after a miscellaneous docket is opened and an order enters confirming the award. And I don't know that you appeal from the order as opposed to from the final judgment, and I sure as heck hope we don't care very much.
Yeah.
No, I agree with you.
On what, we don't care very much, we don't have to get there, or on the distinction?
On the distinction.
Okay.
But, so I have nothing further unless the court, other than I sort of renew our request, because I think this court lacks jurisdiction because the award is the single justice decision is interlocutory, and there is absolutely no case law supported or any statutory basis to allow this court to exercise its jurisdiction. And there was a warning. Look, the single justice said, look at all these cases. Here you go. Withdraw, show me cause why you continue, and they continue to prosecute the appeal. We moved twice. We moved to strike the appeal. We also moved to dismiss the appeal.
You're stepping in more trouble, okay? We have, as a panel, jurisdiction under Section 18 as a panel. So you're suggesting that because it came through a single justice, we lose that jurisdiction. I don't know that, again, I don't think we have to decide this question, but I don't think that doesn't make a lot of sense to me.
I'm suggesting
The
that there's one.
decision
Sorry.
of the Superior Court judge could have been appealed to us, yes or no?
Correct.
To a panel?
That's correct.
Okay, so when you say we lack jurisdiction, I struggle with that because I see a statute that I read to grant us the power to decide that. You're suggesting because it came through a single justice, we lost that.
I'm saying you get one shot here, and it's interlocutory in nature when it comes back. Because and I think there's a distinction that the court is missing. There's a distinction when I issue the appeal versus the opposing party. When I issue the appeal, I have the right because my motion to confirm was denied, and I have a statutory right. I also have an interlocutory right. But when the single justice is why we're up here, we're not up here about a confirmation, which gives you that statutory right. We're here on a different reason, and that's why I think the appeal is frivolous. Had they waited, as we have articulated, for this to go back down and be confirmed, you're totally correct.
Thank you, that was helpful.
All
Thank
right,
you.
I don't think the panel has any further questions. Again, I want to thank you both for preparing yourselves so quickly in a short period of time. It's not often that we expedite appeals. It's important to do so in this case. We appreciate your answering all of our questions. So thank you very much.
Thank
We'll
you.
take the case under advisement. Thank you all.